This video features two explosive courtroom hearings where defendants turn routine legal proceedings into complete chaos, and face instant consequences for it. What should have been calm, procedural moments quickly spiral into shouting, insults, and shocking statements that force judges to take immediate action. In the first case, a defendant appears by video for what was supposed to be a simple plea hearing. Instead, he makes it clear he has no respect for the court, repeatedly interrupting the judge and claiming the process is a waste of his time. When the judge attempts to explain the purpose of the hearing, the situation completely collapses. The defendant unleashes a profanity-filled rant, hurling personal insults and slurs directly at the judge. Within seconds, the judge has had enough and holds him in contempt of court. The hearing ends in chaos as deputies move in and physically remove the defendant while he continues to resist. The second case is even more disturbing. During an arraignment involving domestic violence and property damage charges, the defendant refuses to stop arguing his case. Despite multiple warnings to remain silent, he continues ranting about his wife, court bias, and alleged violations of his rights. Then, the moment that changes everything, he openly states he's trying not to kill her. The courtroom goes silent. The judge immediately orders him into custody, citing the serious threat made on the record. Moments later, bail is set at a staggering $225,000. These hearings are a powerful reminder: what you say in court matters, and one sentence can change everything.
Good afternoon. My name is Walt Weaver. I'm the judge of Potter County Court of Law Number 1. I'm going to be hearing your case today. I've reviewed your plea papers, Mr. Rico. It appears to me you're ready to waive all your constitutional rights in exchange for a plea bargain agreement. But you do have an absolute constitutional right to appear in my open courtroom and face your accusers. Or you could also choose not to use that right as well and agree to appear by video. Are you agreeing to appear by video?
If I can, man, you could just like figure it out in court and I guess.
Are you saying you don't want to do this on video?
I'm not trying to be in court hearing and doing stuff on here. I just ain't got time.
Mr. Rico, it's real simple.
I don't got time to be here, man. If you can, just do your job or do whatever you're doing or something, man. But I don't really care what you do, man.
I'd love to do my job, but part of my job.
Not my job, dog. It's not my fucking job, all right? I don't give a fuck what you look like. You know what I'm saying? Your job is gay.
I'm gonna hold you in contempt.
Hey, bro, I don't give a fuck what you talking about, man. All right? I don't give a fuck what you talking about, man.
Bye.
So, dude, get a job. You be a street go.
Well, do we need to preserve this as evidence now since that's resisting? All right, don't delete the YouTube video. That's unfortunate. Hey, Ethan. Keep them coming, man.
I apologize, Your Honor.
Oh, it's not your fault. That's part of our part and parcel. Boy, he's so little, and look how much people he's got. Could you please put him, Miss Morris, on a transport next time so we can get it done? Boy, if that's not the funnest name I've said all day. Man, it's too bad Mr. Rico could have gone home today. He decided he'd rather stay.
You might have got a new prosecutor today.
Well, it's all live. You saw him fight the deputy. Technically, he's under arrest in a jail. Do you have to prove that, Ellen?
You're before the court today making first appearance, Raymond, on 2 charges. The first is malicious mischief in the 3rd degree. It's a gross misdemeanor subject to 364 days in jail and a $5,000 fine. Second is harassment, domestic violence. That's also a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. Because the charges have domestic violence enhancements, they are something where if you're convicted of them, it would result in your inability to possess firearms.
I don't own a firearm. That's
okay.
what I told
Again,
you.
I have to let everybody know whether you have guns or not.
So I was denied due process. I have paperwork that proves that I owned the car before I was married. So therefore the car is mine. And since we're in separation, no judge has divided property yet. So technically the car is still mine. So I wrote on my own car. That's a fact. Here's the paperwork. I
We're
sit
not
down
having
at the
a
bank.
trial today.
Well-
We're having your arraignment.
Okay.
You're entering a not guilty plea.
I was denied
You've
due
told-
process,
hold on,
sir.
Hold on.
You said I could
You've told,
speak.
no, I
didn't wanna
didn't. I
criticize.
said you should exercise your right to remain
I choose
silent.
not to, sir.
Your attorney, if they were saying there, would not have you making factual statements on the record.
That's my discretion, sir. Because I believe there's Fourth Amendment charges. I was denied all kinds of rights, and I will be coming back with a vengeance. I have
Are you
paperwork.
threatening the court?
I am not threatening the court anything. I'm not threatening anybody.
You just-
I have the
you
right
said
to
you were
sue.
coming
I have
back
the
with
right,
a
I have the right to sue this city, and that's what I just said. So if you want to take that farther than that, that's up to you. I did not say that. I'm
You
making
said
it
you are
clear.
coming back with a vengeance.
With an attorney.
On
It
the
doesn't have
record.
anything to do with me. That's not a threat to you. The city. I said I'm suing the city. So you do what you want today. Go ahead and hold me in contempt. Go ahead. I'm suing the city. I will be suing the city. If you will take that as a threat, then that's fine. I will be talking to the city attorney. I've already talked to the city. I'm talking to people. I talked to the police chief already.
Yeah, I've seen how you've conducted yourself. so
Yeah,
far.
that's right. Because I'm being wronged. It's my house. She had no business being there. And she hasn't even lived there for 6 months. She hasn't paid a bill for 8 months. She can't just come there. I have rights.
You do?
Just because she's entitled to
So
be
again,
able to
we've-
be on the
again,
property
we've
doesn't
talked
mean
about-
she can just come.
We've discussed your rights today. We're not going to litigate your case today.
Do I have the option to
This is-
speak with the city attorney
This
as
is a
well?
criminal court.
Do I have the option to speak with the city
Not once
attorney?
you say you're going to be hiring an attorney.
Do I have the option to speak with the city attorney? I'm not hiring an
Not
attorney.
today.
I want to speak with the city attorney.
Not today.
Okay, when would I be able to do that?
That's me, sir, and I will give you my card.
Okay,
But we do have some release conditions we will be requesting.
Okay. Go ahead, Ms. Carmen.
Yes, Your Honor. We are requesting a formal no contact order with victim notification.
it should have been me filing.
Hold.
She's
Please,
harassed
sir.
me.
Please, sir,
All right, go ahead.
the facts of this case are highly concerning with regard to the threats that were made. These folks are in the midst of a dissolution. Statistically, through peer-reviewed literature, that is one of the highest risk times for partners who are splitting for domestic
Well, what about the
violence.
time I got punched in the chest 5 times? Nobody did anything about that, and I reported it to the officer. Upon arrest, I told him 2.5 months ago, I've been punched in the chest. I will take a lie detector test for that and pay for it. And I received
At this point,
nothing.
the city attorney's making her release recommendation. You need to let her finish.
I was denied due process. You guys didn't take my complaint. So you didn't even take my complaint. And then you don't want me to call it racism. You didn't even take my complaint.
The only thing we are doing today, sir, is you have entered a not
Well, there
guilty
should be
plea.
equal treatment under the law, and I have not
We're not
received it.
litigating your case today. I've already told you that. You've seen every other person come up here. I've entered not guilty pleas. I've set
Well, I
release
want to put this
conditions.
in the record is,
Sign
can I
it.
give this to the attorney so she can follow up on this? This is my proof that the car is mine. I don't go to her. I am at my house. She came to me. I never go to her. So why is the order
Please-
against me when I
please
don't
let-
even deal with her?
Please let the city attorney finish her recommendation. So we're walking on a very fine line right here with your conduct in court today.
Okay, I'll stop. Sorry.
Thank you.
I don't even go to Oregon, sir.
I will
She lives in
add,
Oregon.
I will add, because Mr. Briggs has brought it up, we are not seeking to remove him from the home that he is residing in.
How you gonna, she don't even live there. Are you kidding me? She doesn't live there. I paid the mortgage there for the last for 4 years I paid the mortgage. And I can prove that.
Mr. Briggs.
You're gonna remove me from my home? What are you talking
She's
about?
saying she is not.
Why are you even saying that?
Because,
She don't live there. Her address is in Oregon. Why are you even saying that?
because Mr. Briggs has brought it up, we are not seeking to remove him from the home that he is residing in.
How you gonna, she don't even live there. Are you kidding me?
Your Honor, the reason that I'm bringing this up is that the victim has requested a civil standby so that she can go get her personal belongings from the home.
Property has not been divided by the court. She has her personal items and her personal belongings. And then the court has to divide the property. That's what I've been waiting for. I've encouraged her to file the divorce papers, sir.
I will be finished here shortly, Your Honor. The proposed NCO that we have drafted, after contacting Battleground to make sure this is something that they could do.
That's against the law. No way.
Is that she can call for a civil standby where they would go to Mr. Briggs' home. She has the same 15 to
She can't
20.
come there and just take whatever she want out of the home. It hasn't been divided by the divorce court. I believe she's demonically possessed by the Jezebel spirit. So I don't want her around me. There's a visceral reaction that I haven't felt around a person in many years. If I'm from here to her, I want to throw up. I literally cannot be around her. And I've required that she not come to the house. She came to the house because I refused to get the HELOC with her to help her pay off her bills. So she came to the house the next day, and then that's when everything started. I was sitting there with my brother-in-law, drinking beer by myself, like I always do. I didn't go to her. She came to my house. And she has forfeited, I haven't proved it, but she's forfeited her right to the property. She hasn't paid a single bill there in 8 months. And when she left, the moment that she took her and got a new bank account at Columbia Credit Union, that's the day of separation. That was over 8 months ago. She cannot just come to that property.
I have jurisdiction for a victim to be able to retrieve property.
What would I be
When a
keeping
no
from her,
contact-
sir? She has all of her clothing. There's a table and a side table in the bedroom. That's all that's there, and whatever's in the garage. I haven't kept her from anything. I'm trying not to kill her. Come to me.
Okay, so, Your Honor.
Okay.
That's not.
I
Now, hold
I did
on.
actually ask he be held on $10,000 bail.
Listen, sir. Listen.
You can't.
I'm not saying it like that. I'm saying that I've tried to keep her away because of violence. I don't want.
Very much keeping with statements. that
Oh
were
my
made
God.
at
Do
the
you
scene.
understand? Does anybody
Yeah,
understand?
take
I
him into
didn't
custody.
never touch her.
Officers, take him into custody.
I never touched her. I didn't want to harm her. That's what I've been doing the whole time. Man, I'm getting crunk down here and it's gonna be on. This is prejudice and
Okay, I'd like-
racist as hell.
I'd like no bail.
You're racist.
Well,
I have
he
not
just
done
threatened-
anything to her.
He just threatened to get crunk on the court.
So what? What is that? So you're taking away my freedom of speech? I can't express myself now?
Can't
I
threaten.
haven't committed any crime. I haven't touched anybody.
All right. So
I don't want her at the house. That's what I've tried to avoid.
at this stage, we're gonna set Mr.
Hey, never,
Briggs-
she punched me in the chest. I'm prosecuting her, so you take that. I want to see somebody about that right
we're gonna
now.
Set Mr. Briggs.
And I'm pressing charges on her.
About 1 week.
She punched me 5 times and I will take a lie detector and pay for it.
We're gonna
Can I
set
speak to
Mr.
somebody
Briggs
and press
over to
charges
the
on her?
12th of December,
You know
2024
what I'm saying?
at
Hey, you know
8:30
what? My
a.m.
shoulder, I'm in, we're giving you extra.
The release conditions in place are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. I'm signing off on a standalone no contact order.
So I said I didn't want to kill her and I've never threatened to kill her. I'm just expressing to you that I don't want any bodily harm towards her. And you're arresting me for that. And it's a freedom of speech. I didn't touch her. I've never put a hand on her. She punched me. Can I press charges? Can I see someone to press charges on her right now? Your Honor? Your Honor?
This is your arraignment today, sir, on criminal charges. You've made a number of threats on a recorded
I
record.
didn't make any threats to anybody.
Well, we'll listen
How is
back.
that a threat? Freedom of speech. I didn't threaten anybody. I didn't say I want to kill her. I said I don't want to.
Sure. Well, we'll listen to what they say on the record. You're being recorded. I told you to remain silent.
Well,
Your
hey,
choice.
I knew you was gonna do this. I knew you was gonna wait until I slipped and then you was gonna throw me in jail, and that's fine. Because I'm coming with Trump. That's not a threat. That's my personal lawyer that I'm gonna get to fight you guys
When
with.
people threaten killing someone on the record, sir, I take
I
that
didn't threaten to
extremely
kill her.
seriously.
That was not a threat to kill her. I didn't say I'm going to kill
We're
her.
recording.
I said I don't want to. And
That's
that wasn't
fine.
even, that was just a figure of speech.
It's recorded.
I don't care if it's recorded.
We're on intensive pretrial release. At this time, I'm going to impose bail in the amount of $25,000.
And then, Your Honor, if it is posted, could we have the victim notification?
Victim
requirement?
notification will be put in place.
Thank you.
This is a railroad, man. I'm telling you.
This video brings together two courtroom hearings that start off routine but quickly descend into absolute chaos, revealing how fast things can go wrong when defendants lose control in front of a judge. These moments are raw, unfiltered, and deeply uncomfortable to watch, not because of complicated legal arguments, but because of how quickly words, attitude, and emotion turn into real-world consequences. In the first hearing, Mr. Rico appears remotely for what is supposed to be a simple plea-related proceeding. From the moment the connection comes through, it's obvious that something isn't right. His body language is tense, his tone impatient, and his attitude openly dismissive. Instead of listening, he immediately makes it clear that he believes the court is wasting his time. He repeatedly interrupts, talks over the judge, and acts as if the entire proceeding is beneath him. The judge attempts to maintain control of the hearing, calmly explaining why he is there and what the court needs to address. She speaks slowly, clearly, and professionally, giving him multiple chances to settle down and participate appropriately. But rather than de-escalating, Mr. Rico becomes more agitated. Each attempt by the judge to explain the process seems to frustrate him even more. Suddenly, the tone shifts from disrespectful to outright hostile. Mr. Rico explodes into a profanity-laced rant, directing insults straight at the judge. He uses offensive language and slurs that immediately cross every line of acceptable courtroom behavior. At this point, the courtroom atmosphere completely changes. This is no longer about a plea agreement or scheduling, it's about control, authority, and the integrity of the court itself. The judge does not raise her voice. She does not argue. She does not trade insults. Instead, she does what judges are empowered to do when faced with blatant contempt. She finds Mr. Rico in contempt of court, right then and there. The decision is swift and final. The hearing is over. But even then, the chaos doesn't stop. As deputies move in to take him into custody, Mr. Rico continues to resist. He struggles physically, refusing to comply, turning an already disastrous situation into something even worse. What could have been handled calmly minutes earlier now ends with force, restraints, and immediate consequences, all because he could not control his words or his temper. The second hearing begins very differently but ends with consequences just as severe. Mr. Briggs appears in court facing charges related to malicious mischief and domestic violence. From the start, he insists on arguing the details of his case, despite being clearly told that this is not the time or place for that discussion. He fixates on a dispute involving a car, claiming it is solely his property and that he has been denied due process. The judge repeatedly explains the purpose of the arraignment and reminds Mr. Briggs that this is not a trial. He is warned, more than once, to stop talking about the facts of the case and to remain silent when instructed. Each warning is clear, direct, and legally sound. But Mr. Briggs refuses to listen. Instead, he continues to rant about his wife, about alleged unfair treatment, and about perceived bias from the system. His voice grows louder. his frustration becomes more visible. The judge attempts to slow things down, to prevent Mr. Briggs from damaging his own case, but the defendant simply will not stop. Then comes the moment that changes everything. In the middle of his rant, Mr. Briggs makes a statement that immediately sends shockwaves through the courtroom. He says he is trying not to kill her. The words hang in the air. There is no confusion about what was said. There is no misunderstanding about how serious it sounds. This is no longer just an argument or an emotional outburst. This is a perceived threat made directly on the record. The judge reacts instantly. Mr. Briggs is ordered into custody without hesitation. The tone of the hearing shifts dramatically as the court moves from managing a disruptive defendant to addressing a serious safety concern. The judge makes it clear that statements like that cannot be ignored, dismissed, or minimized. Mr. Briggs, realizing the severity of what just happened, attempts to walk it back. He claims the statement was a figure of speech. He argues that it was protected by freedom of speech. He accuses the court of racism and insists that his words were taken out of context. But in a courtroom, context matters, and so does the record. Judges are not required to assume the best interpretation of a defendant's words, especially when those words involve violence. The court must consider public safety, victim safety, and the credibility of the threat itself. The judge explains that when someone makes a statement like that during a domestic violence case, it cannot be brushed aside. Regardless of intent, the risk is too high. As a result, bail is set at an exceptionally high amount, $225,000, reflecting the seriousness of the threat and the court's concern for safety. Both of these hearings serve as powerful reminders of how unforgiving the courtroom can be when emotions override judgment. Judges are not there to debate, to argue, or to absorb abuse. They are there to enforce the law, maintain order, and protect the integrity of the legal process. In both cases, the defendants had opportunities to remain calm, to listen, and to protect their own interests. Instead, they chose confrontation. They chose anger. And in doing so, they transformed manageable legal situations into life-altering consequences, right before everyone's eyes. What makes these moments so striking isn't just the punishment, it's how fast it happens. A few sentences, a few seconds of lost control. And suddenly, freedom is gone, bail skyrockets, and the legal road ahead becomes far more difficult than it ever needed to be.